Loyalty is an essential element in the lawyer's relationship to a client. If in advising a client about the disposition of property after death, the lawyer must first determine whether a living trust is appropriate for that client. If so, the lawyer must then ensure that the living trust meets the client's needs. If the lawyer is employed by a corporation selling the living trust rather than by the client, then the lawyer's duty of loyalty to the client could be considered compromised. I added the word considered. Lawyer shall not represent a client if the lawyer's exercise of independent professional judgment in the representation of that client may be materially limited by the lawyer's responsibilities to another client or to a third party or third person. Lawyers shall not accept compensation for representing a client from one other than the client unless, one, the client consents. There is no interference with the lawyer's independence of professional judgment or client-lawyer relationship, and information relating to representation is protected. In light of this duty of loyalty to the client, a lawyer who assembles, reviews, executes, and funds a living trust document should be independent counsel paid by the client representing the client's interests alone. Now, we can easily take that, and how do we apply that as a fiduciary? A fiduciary can only, other than being able to disclose otherwise, only offer those products and services which the client has accepted and that compensation coming from the client.